everyone, and welcome to Corporate Law and Business Ethics. My name is Jobene Edu, your lecturer for this course. Before we go on, I say a huge congrats to you on your successful completion of your university program, despite all challenges experienced, and I wish you all great success. This course is divided into two segments, that is, Corporate Law and Business Ethics. Corporate law aspect basically takes you through the process of formation of companies to winding up of companies. We will also look at the Nigeria Institute of Management as a corporate body. While business ethics is basically about how you run your business in an acceptable manner. I do hope we have a great session. Like most laws, corporate law is one of the received laws from the British legal system. The first law on regulation of companies was the Companies Act of 1912. However, this law applied only to Lagos Colony. But in 1917, another law, known as the Companies Amendment and Extension Act, was passed, and this extended the application of the law to the whole country. Subsequent Companies Act of 1922 repealed that of 1912 and 1917 respectively. The Companies Act of 1968 repealed that of 1922, while that of 1990 replaced that of 1968. One significant thing about the 1919 Act is that it established the Corporate Affairs Commission and was the first all-encompassing law in relation to the regulation of the affairs of companies in Nigeria, and that law was known as the Companies and Allied Matters Act of 1990. Again, the Act was repealed and replaced with the Companies and Allied Matters Act of 2004, which is the law presently in operation, with its 2018 amendments, which has just been signed into law this year, 2020. The Act is divided into three sections, Part A, B, and C. While Part A deals with companies, Part B deals with business names, that is, sole proprietors. For instance, you want to register a barbing salon, a cake shop, or boutique, which will be run by only you. Then your registration falls under Part B of CAMA. By CAMA, we mean the Companies and Allied Matters Act. Also, partnership falls under Part B of CAMA, while registration of your NGOs, foundations, social clubs all fall under Part C of CAMA. However, for the purpose of your study, our focus will be on Part A, that is, companies. The principal body regulating the affairs of companies in Nigeria is the Corporate Affairs Commission, established by the Companies and Allied Matters Act 2004. The CAC is a body corporate under Section 1(2) of CAMA. This means that the CAC is a legal or artificial person. It can sue and be sued in its corporate name. It can own property, and it has perpetual succession, amongst other things. The CAC comprises of a chairman who is appointed by the president, registrar general who must be a legal practitioner of not less than 10 years post-call experience and must be versed in law and accounting. He represents the commission in court proceedings. The commission also has other members drawn from various professional bodies and representatives of certain ministries, such as Labor, Justice, Manufacturers Association of Nigeria, Securities and Exchange Commission, Nigeria Bar Association, a representative from Ministry of Trade, Finance, Economic Development, respectively. A representative also of the accounting profession, ICANN. This is covered by Section 2 of CAMA. Another major body regulating the affairs of companies is the Securities and Exchange Commission. This commission, however, deals with public companies. Functions of the commission. The commission is saddled with the function of implementing the provisions of the Act. It ensures companies are in compliance with the Act by investigating the affairs of companies. It ensures companies are not engaged in fraudulent or illegal activities. The Commission establishes registries in almost every state of the Federation. As at today, almost all the 36 states of the Federation has a corporate registry. The Commission also does all that is necessary to implement the provisions of the Act as it relates to companies. It is important to note that the court with jurisdiction, that means the court that has the right to hear or determine matters as it relates to companies, is the Federal High Court. We have earlier stated that Part A of CAMA deals with companies. So by the provisions of the Act, there are basically two types of companies in Nigeria. That is, all companies in Nigeria are either public or private companies. Each of this is either one of three types. That is, either a company limited by shares, a company limited by guarantee, or an unlimited company. For the company limited by shares, what it means is that the liability of the members, that is what the members owe the company, is the amount which they have not paid on the shares taken up by them. That is, for instance, if a member takes 2 million shares in a company and he pays for only 1 million, his liability is limited to the 1 million shares he has not paid for. If anything happens to the company and members are called to pay all they owe, all it will bring is the amount payable on that 1 million shares he has not paid for. With regard to a company limited by guarantee, these are companies usually set up to promote a particular cause, like sports, education, religion, charity, or any noble cause. They do not have a share capital, and the liability of the members is limited to any amount they undertake to contribute if the company is wound up. The minimum limited set by law is 10,000 naira. Please note that to register this type of company, that is a company limited by guarantee, the consent of the Attorney General of the Federation is required. The company limited by guarantee is similar to the NGO under Part C. However, one major difference is that while the LTD GTE, that is the short form for your limited by guarantee, is a profit-making company, the NGO is not. Also, while the limited by guarantee has directors, the NGOs have trustees. And only this year, that is 2020, consent is now required to register an NGO. Before now, no consent was required. The profits of a company limited by guarantee must be directed towards its object and not to be shared by the members. For an unlimited company, the liability of the company is synonymous to that of the shareholders. By this, their liability has no limit. That means, if the company is unable to pay its debts, the personal assets of the members will be used to offset the debt of the company. Therefore, an unlimited company is not an advisable company to set up. Talking about the differences between public and private companies, the memorandum of each states their status as either public or private. Membership is limited to 50 for private companies, and there is no limit for membership of a public company. A private company will usually end with the word limited or LTD to show it is a private company, while a public company ends with PLC to show it is a public company. For instance, you have First Bank PLC. The PLC there shows it is a public company. You have GT Bank PLC as well, among others. On the other hand, you may have Ex Nigeria Limited. The limited that shows that it is a private company. After incorporating a public company, it must be issued a certificate of commencement of business before it can start doing business. And it is required to hold a statutory meeting and file its statutory reports within the first 6 months of its incorporation. Also, appointment of directors for private companies can be done by a single vote, while each director of a public company must be appointed by separate votes unless there is a resolution to appoint all of them by a single vote. Again, any person, irrespective of age, can be appointed a director of a private company. All you need to show is that he is competent to occupy that position. But for a public company, a person above 70 years of age cannot be appointed a director of a public company unless he discloses this fact to the shareholders. Also, the person to be appointed company secretary of a public company must be either a legal practitioner, a chartered accountant, a chartered secretary, a firm of any of the above, or a person who has occupied that position not less than 3 to 5 years preceding his appointment. It is important to note that you can convert your business to a limited company. For instance, you have a cleaning business and you wish to expand and you want the business to have directors and shareholders. You can apply to the commission to convert your company to a limited. Also, a public company, that is a PLC, can convert to a private one. And a private company, that is the limited, can also convert to a PLC. How do you register your company? First, you must have a name. For instance, Mayfair Nigeria Limited. You submit the name at the commission, and once it is approved, you start the online process of registering your company. You fill in the names, addresses, phone numbers, and email of the members and directors, their shareholding, that is the number and type of shares they hold, the address of the company, the memo and articles of the company, and the statutory declaration of compliance, which shows that you have complied with the requirements of the law in registering the company. Now, talking about this Memorandum of Association, what is it? The Memorandum of Association of a company deals with the public in the sense that it gives members of the public the opportunity to know what your company is about. It contains the objects of the company, that is, the type of business carried out by the company, while the Articles of Association deals with the internal running of the company. It contains matters like borrowing powers of the company, the maximum limit of directors, how meetings will be held, how shares will be dealt with, amongst others. It is the constitution of the company. What is the effect of having a memorandum and articles of association? The first is that it serves as a contract under seal. That is, a formal contract, a written contract between the company and members and its officers. It is also a contract between members and officers of the company that they will perform and observe the contents of the memorandum and articles. Another effect is that any money yet to be paid by any member on shares taken up by him is considered a debt due from him to the company. Now you know the various types of companies and have probably decided on the type of company you want to register. So you go searching for a property, you hire or purchase office equipment, you enter into contract with suppliers, you start sourcing for businesses, you start sourcing for clients, then you call your lawyer or any authorized person to incorporate the company for you. You are considered a promoter. Who is a promoter? By Section 61 of the Companies and Allied Matters Act, a promoter is a person who undertakes to take part in the formation of a company and takes necessary steps to get it going, or one who, with regard to a proposed or newly formed company, undertakes in raising capital for it. That is, even when you have formed the company, but this person goes around raising money for the company to take off, he is considered a promoter. Know that the lawyer or agent who you consult to register the company for you is not a promoter, but an agent for the purpose of bringing the vision or the dreams of the promoter to reality. Note also that a person who takes no active part in forming a company but leaves all the running around for the setting up of a company to others with the understanding that he will ultimately benefit from it is considered a promoter. This is because he conceives the idea to form the company with the sole aim of benefiting from it. What is the role of a promoter in the formation of a company? The promoter helps in securing directors for the company, he raises capital for the company, he buys properties for the company, he enters into contracts on behalf of the company. Those are the roles he performs in bringing the company to being. Note that where he enters into contracts on behalf of the company, he is personally liable until such contracts are adopted by the company. What is the position of the promoter towards the company? He stands in a fiduciary position towards the company. That is, one of utmost good faith. He must act with sincerity of purpose towards the company, even after the company has been formed. Where he fails to show good faith towards the company, he shall be held liable and must compensate the company for any loss suffered as a result of its actions. The fiduciary position of the promoter towards the company rests on two major duties owed the promoter to the company. This is covered by Section 62 of the Act. The first duty is that of disclosure. The promoter must disclose all material facts known to him with respect to the formation of the company. He is not expected to lie or withhold any information from the company. If he bought a particular item or entered into a particular contract, he must give full details of the transaction. Also, he must not make secret profits or gains. That is the second duty. Any profit made by the promoter in the course of promoting the company belongs to the company and must be declared. He is not expected to keep such profits to himself. If he gets a property for a particular sum, he is not allowed to state otherwise. If he buys a furniture for 10 million and he says he bought it for 20 million and keeps the profit to himself, then he has made secret profits and he will be held liable. How is a promoter rewarded or remunerated? That is what it is, reward for all these efforts he has put in to setting up the company. At common law, that is before the act, the promoter was not entitled to any form of remuneration. He didn't have any reward unless there was a valid contract in place between him and the company. And no action could be taken against the company for failure to reward or remunerate the promoter. This is because the company is not yet in existence. And the position of the law then was that you could not enter into a contract with or on behalf of a non-existent company. However, with the coming into effect of the Act, that is under CAMA, particularly by Section 71 and 72, which deals with pre-incorporation contracts, the promoter is entitled to a reward for its efforts once his actions have been ratified by the company. That is, once the company has adopted those contracts, then the promoter gets paid. The essence of this is to discourage the promoter from breaching his fiduciary duties towards the company. That is, to make the promoter or to discourage him from earning secret profits. Then he is remunerated. Where a promoter acts in breach of his duties towards the company, what can the company do? The company can seek the following remedies against the promoter. First of all, they can make him to account for all the property or wealth he has acquired through fraud. And there is no limit as to time for which this remedy can be sought against the promoter. That means at any point in the life of the company, when the improper action of the promoter is discovered, he will be held accountable. He will be called to account for his action. Another remedy against the promoter is rescission. To resign, that means to cancel. That means any contract the promoter has entered into can be cancelled by the company once it is discovered that the promoter has acted in bad faith towards the company. The company can cancel it, and the promoter will be held liable from any cost arising from such cancellation or rescission. Another remedy is recovery of profits. Where the promoter has made secret profits from any transaction, such profits will be recovered from him by an action in court. Also, the company can ask for damages against the promoter. When a promoter is in default of his duties, then in addition to the above remedies, the company can also file an action for damages against the promoter. Now, what are these damages? For clarity of purpose, Damages are compensatory claims against a company or a person, usually monetary in nature and in large amounts. So where a company has suffered a loss by reason of the actions of the promoter, and the promoter has acted in such a manner that has put the company in a difficult situation, the company can claim damages against the. When incorporating a company, the nature of business the company intends to carry out is stated in its Memorandum of Association. If a company is set up for the purpose of producing table water, for instance, it is not expected to engage in the business of selling bakery products or go into oil exploration. If it does, this means it has acted beyond its scope of operation, and such action will be said to be beyond its powers or ultravirus. The term ultravirus means beyond powers. A company is not expected to go beyond the objects stated in the object clause of its Memorandum of Association, as to do so will mean the company has acted ultravirus. Please note that an action can be ultravirus the directors, but intravirus the company. That is, the directors may act beyond the powers conferred on them by the articles. For example, the directors may have borrowing powers not exceeding a particular sum, say 10 million naira, and they borrow beyond that. They have acted ultravirus. This act by the directors can, however, be ratified by the members in a general meeting, thereby validating same. However, once an action is ultravirus the company, such act is null and void. This was the position of the law before the act. Anyone who transacts with a company acting beyond its powers, acting ultravirus, cannot recover against the company. That means if you enter into a business with a company that is not acting in line with what is contained in its Memorandum of Association, that transaction is cancelled. It is null and void, and you cannot recover against the company. You cannot sue the company. You have lost totally. That was the position before the coming into effect of the Act. A company is said to have acted ultravirus when it does business not stated in its objects. And anyone who transacts with such a company cannot recover against the company. This is because a person is expected to find out if the company he is dealing with actually carries on the business he claims to do. If he fails to do this, the loss is his to bear. This is known as the doctrine of constructive notice. This rule states that everyone dealing with a company is expected to know the contents of its registered documents. The position of the law prior to Kama occasioned injustice against persons dealing with companies in good faith. Therefore, it became necessary to revisit the Ultravirus Doctrine. The Act therefore modified the law with regard to the doctrine. Now, the position is that where a company is about to act beyond its powers, any member or any debenture holder can file an injunction in court to restrain the company Also, a transaction cannot be declared void merely because it is ultravirus the company. This is covered by Section 39 and Section 300 of the Companies and Allied Matters Act. Thus, where any act or conveyance or transfer of property has been concluded, it cannot be declared invalid by any court. Where a court sets aside a transaction or prohibits any act, it may allow compensation for loss or award damages to any person or company for any loss sustained under such transaction. But it will not give any award for losses which a party anticipates. That is, where you already know that that act is ultravirus and you still go ahead to do it, you will not be awarded any damages. Of importance is the fact that the constructive notice rule has been abolished under Section 68 of CAMA. This means that where a person is transacting with a company, he no longer has the responsibility or burden of having to find out if the company actually does the business it claims to do. The company is held solely responsible for any information it lets out. And if found to be false, the company is held liable for it. Also, there is a presumption of regularity in favor of any person dealing with a company. That is, everyone dealing with a company is presumed to believe that all is well with the company and the company is actually what it says it is. Now we already know how to register our company. We've also seen who the promoters are, and we also know the consequences of a company acting beyond its powers. Now, what is the consequence? What is the legal consequence of incorporating a company? What is the effect of registering a company, in other words? The consequence of incorporating a company is that that company becomes a person in law. That is, it becomes an artificial person. It can do everything a natural person can do in its corporate name. The company becomes separate from its owners. It becomes separate from its subscribers. If I own a company, the company is different from me. If you want to sue the company, you sue the company in its name. The company may be buoyant, that is, the company may be rich and its members broke. And you can have rich members and a broke company. Also, the company has perpetual succession. This means that the company exists forever. It does not die. It can only be killed through the process of winding up. Persons come and go, but the company remains. Another consequence is that the company can be sued and can also sue without including its members. And any award given against the company can be enforced against the company to the exclusion of the members. The company also has the right to own, sell, and purchase property the way a natural person would. That is, the way you and I can buy our land and houses, a company can also do the same. One of the most profound effects of incorporation is that of limited liability. That means that the shareholders' debt to the company, that means what they owe the company, is only limited to the amount they have not paid on their shares. They cannot be compelled to pay beyond this to the company. The company also has a common seal through which it validates all transactions and actions by affixing same on documents when required. Some of us may have seen that seal. It is usually a metal object that has the name of the company embedded on it. So when the company wants to sign any document, after signing, it places that seal to authenticate that document, to show that that document actually emanated from that. Even though we say a company is different and separate from its owners and can be held solely responsible for its actions, there are, however, instances where the owners and officers are held liable for their actions in running the affairs of the company. The court will go behind the artificial covering of the company and hold those behind it accountable. This is the concept of lifting the veil. The circumstances under which the veil of incorporation will be lifted are: 1. Judicial intervention. That is, where the court deem it necessary in order to reach a fair and just decision in a matter regarding the company, to seek those running the affairs of the company to help it reach such decisions. Some of these circumstances include trust. We all know that the property of the company is held in trust by those who control the company. That is, the directors, the shareholders. Where they misuse the resources of the company, they will be held personally liable. They cannot say because the company is separate from the owners or from those who run it, then they cannot be held liable. They cannot hide under the corporate veil. Another instance is fraud or improper conduct, where those in charge of the company hide under the corporate veil to perpetrate fraud or to steal the company's funds. They will be held personally accountable for their actions. Another instance is residents of enemy companies. Here, a company may be set up and those behind it may be citizens or members of enemy countries. Or the country may be set up for a particular seemingly legal purpose, whereas it may actually be, for instance, a terrorist company. In such instances, the veil of incorporation will be lifted to determine those in control of such companies, to establish their status and bring them to book. Another circumstance is tax purpose. Every director or member of a company is expected to pay their taxes personally. They cannot hide under the corporate veil to avoid this responsibility. They cannot hide under the company's tax. They must pay their taxes personally, else they will be held personally liable. Another instance also where the veil of incorporation will be lifted is under statutory or legislative intervention. That is, where the company breaches the provisions of the law. In that case, the owners will be held personally liable. These instances include: 1. Where the minimum number of members or the directors have fallen below 2 for more than 6 months. Where this happens, each member will be held personally liable, and that liability is to a fine for every day of default. Also, Companies limited by guarantee are not expected to distribute profits among the members under the law. Where this occurs, such members will be held personally liable. Again, by Section 200 of CAMA, where the funds of a company are diverted for personal use, those guilty will be held personally responsible. Again, where the company is involved in fraudulent trading, particularly public companies, the owners and officers will be held personally liable. Now, talking about shares and debenture, what does it mean when it is said that you own shares in a company? Or what does it mean when you say you are a shareholder of a company? It simply means that you have rights in that company. You have interests in that company, among other things. You are also liable to the company on any amount you owe on the shares held by you. What are shares? Shares represent a unit of the bundle of rights and liabilities which a holder has in a company as provided in the terms of issue as stated in the Articles of Association, and includes the right to attend and vote at meetings of the company. The law does not allow issue of shares without rights to vote. That means once you own a share, you have voting power, and does not allow a share to carry more than one vote, except for preference shareholders under Section 143 of CAMA. Who is a shareholder? A shareholder is a member of a company. Types of shares. We have ordinary shares. These are shares that have no special rights attached to them. Those who hold ordinary shares are the risk bearers of the company, and they may not get dividend if the company makes no profit. Then you have founders or deferred shares. They are also ordinary shares, but they are referred as founders or deferred shares because the holders receive dividends after all other classes of shares have been paid. They are taken up by the founders of the company. Then you have preference shares. The holders of these shares have priority over other shares in the company. They are usually owned by those who have invested their funds in the company, and they carry usually a fixed rate of dividend. Then you have redeemable shares. These are shares redeemable at the option of the company. That is, the company has the option of paying back the value of the shares to the shareholder or repurchasing the shares when they are issued and the company decides to buy them back. Such shares are not ordinarily issued unless the company's articles provide that they be issued. Then how are shares issued to the public? First of all, you talk about issuing of shares at a premium. That is, when the shares are issued to the public at a price higher than its actual value. Flotation of shares refers to the ways and means by which a company offers shares to the public. This can be done in one of three ways. The first is by direct offer. Here, the entire risk relating to the shares is borne by the company. That is, where the company sells the shares by itself. If all the shares are sold, the company takes the profit. And if the shares are not fully sold, the company endures the loss. The company issues its prospectus and advertises its shares to the public. The second way is by offers for sale. Here, the company decides not to bear any risk. The company sells the shares to the issuing house and keeps its profit. The issuing house then sells to the public, usually at a higher price, such that even if the shares are not fully sold, the issuing house suffers little or no loss. All the money or all the proceeds arising from the sale by the issuing house goes to the issuing house. This is because the company has already sold to them and the company has made its money already and walked away. So the third way is by placement. And this takes two ways. First, the company sells to the issuing house. The issuing house then sells to the public, keeping the profits. Secondly, the issuing house acts as agent to the company, sells the shares, and gets a commission from the company known as brokerage. We mentioned prospectus earlier. What is this prospectus? The prospectus is a document that is issued by a company to the public when inviting them to subscribe for shares. The prospectus talks about the status of the company. Through the prospectus, you know who the directors of the company are, you know who their shareholders are, you know the financial capability of the company, you see their cases in court, the whole thing, every information you need to know about the company is stated in the prospectus. This prospectus serves as a guide. It helps you to determine whether or not you want to buy shares in that company. Then you also have a share certificate. Any person who has been allotted shares in a company must be given a share certificate. However, you can only be said to be a member of that company when your name is entered in the register of members. Now, the share certificate has your name, the number of shares you hold, it has a share certificate number, and it is signed either by two directors or by a director and the company secretary. And it states whether your shares are ordinary shares, preference shares, the type of shares that you hold is contained in the share certificate. And that is what gives you a right over the company. It is your evidence that you own shares in that company. Now, the capital of a company covers all the assets of the company and includes the share capital and borrowed money. It includes fixed and floating capital. Share capital is the financial value of a company in shares. There are different types of share capital. You have the authorized or nominal share capital. This is the financial value of the company on incorporation. By law, for private companies, the minimum share capital is 10,000 naira and 500,000 for public companies. And subscribers must take up at least 25% of the authorized share capital. So if the share capital, for instance, is 1 million, the subscribers must take up at least 250,000 shares. Issued capital. This is that part of the authorized share capital that is issued to the subscribers. If the share capital is 100 million and 500,000 shares are subscribed for, that becomes the issued capital of the company. Paid up capital. This is the amount of the issued capital that has been paid for by the subscribers. At incorporation, the subscribers need not pay for the shares at that time. But once a call is made on the shares, that is when they are asked to pay for the shares, those shares paid for become the paid up capital of the company. Then you have the reserve capital. This is a part of the uncalled capital, that is shares that have not been requested to be paid for, which the company has decided not to be capable of being called except for the purpose of winding up. This is basically to ensure availability of funds when such event occurs. This, however, is different from reserve fund of a company, which comprises of undistributed profits, which can be freely dealt with by the company. Companies raise capital through different means. The power to do this is implied in its memorandum and articles of association, even if not expressly stated therein. Companies raise capital through charges, debentures, mortgages, bonds, promissory notes, and bills of exchange. What then is a debenture? A debenture is a document, usually, though not always, issued by a company containing an acknowledgement of indebtedness in a specified sum, and is usually given as a charge on the assets of a company. There are different types of debentures. First of all, you have the perpetual debenture. These are irredeemable debentures. They carry no specific payment date or are payable when the company goes into liquidation or when a specified event occurs or after a fixed period of time. You also have the convertible debentures. These are debentures which may be converted into shares at the instance of the debenture holder. Then you have the secured or naked debentures. The secured debentures are those which are secured by a charge to the company's assets, either fixed or floating. While a naked debenture are those not tied to any assets. Redeemable debentures carry a specific date of payment, and the company has an obligation to pay on that date. Then you have bearer debentures, which are payable to the bearer. They can be transferred, and the transferee takes it in good faith and for the value for which it is issued. Then, how do you secure a debenture? You secure a debenture by either a fixed charge or a floating charge. A fixed charge is where the property of the company is used to secure a debenture. For instance, land. The company cannot use or dispose of such fixed assets without the consent of the debenture holder. And for a floating charge, there is an equitable charge on the assets of the company, and it covers movable assets and sometimes the uncalled capital of the company. That is, those shares that have not been called for to be paid. The company can make use of such floating charge such movable assets, and they can even change the form without the consent of the holder. It may dispose of such movable properties in the course of business and purchase new ones. The most important thing is that the assets should be available should the need arise for its realization by the debenture holder. In some cases, the company may not be able to pay its debts. In such instances, what are the remedies available to a debenture holder? He can recover the principal sum and interest by an action in court. The debenture holder can also file a petition to wind up the company. Again, debenture holders holding a particular type of debenture can come together to file an action known as a debenture holders action against the company. Also, the power of sale can be invoked against the assets of the company. Then a foreclosure action can also be taken against the assets of the company. By foreclosure, the company loses all its rights to recover the assets from the debenture holder. Then you have valuation of security. Here, the creditor carries out a valuation of security, and if it is not sufficient to pay off his debt, the balance is applied like any unsecured debenture. A debenture holder can also appoint a receiver for the purpose of recovering the debt. Welcome back from the short break. This is still corporate law and business ethics. Section 1, we looked at the history of law and we traced to 1912. And we looked through up to the 2004 amendments, which is applicable for your present study. But we also know that there is a 2020 amendment which has been signed into law. We looked at the different officers of the Commission, the Corporate Affairs Commission, and their functions. We looked at the bodies regulating companies in Nigeria, apart from the Corporate Affairs Commission, and we did say that the Securities and Exchange Commission is one of them. Also, we looked at the different types of companies, and we said there are basically two. That is, a company is either a public company or a private company. We looked at the differences between the two. And we did say that whether public or private, your company is either a limited liability company, a company limited by guarantee, or an unlimited company. We looked at the Ultravirus Doctrine. We also looked at promoters. And for promoters, we did say that the promoter is the person that goes about, takes steps to bring about the registration of a company. He brings the company to life. He gets a person who does the registration, but that person that actually does it, that is the agent that he contacts, you cannot call that person a promoter. For instance, if he engages a lawyer to register that company for him, you cannot call the lawyer a promoter. The promoter is the person that conceives the idea of registering a company. We looked at the reward for the promoter, and we said that in the past, that is before the act, he did not have any reward. This is because the company is not yet into existence, and it is believed that you cannot enter into a contract with a non-existent company. However, under the Act, the promoter has some form of reward, and he is rewarded if his contract is ratified, that is, adopted by the company. We looked at the duties of the promoter. We said he should not make secret profits, and he must fully disclose. We looked at the remedies against a promoter if he defaults. And we said, number one, he can be called to account for everything that he has done. We also said that he can be asked to pay damages. There is also rescission of account and also recovery of profits. Then we looked at the Ultravirus Doctrine. And we said that the Ultravirus Doctrine simply means when a company acts beyond powers. That is, when a company does what is not stated in its memorandum and articles of association. And such act is null and void. And we looked at the new law that is under the 2004 Act that says that such act is not necessarily null and void anymore. That once a transaction has been completed, it cannot be null and void. We also, of note, mentioned the constructive notice rule, which we said has been abolished. You will recall that under that law, a person is deemed to know the content of the memorandum and articles of a company. If he fails to do that investigation, then any transaction with the company is at his own risk. But under the new law, that constructive notice rule has been abolished. And you are also allowed to presume that all is well with the company you are dealing with. Then we looked at the consequences of incorporation, and we said that a company becomes a person in law once it is registered. We said that it has perpetual succession, it can sue and be sued, and it can also own property. Then we looked at the concept of lifting the veil. That is, that even though we say that a company is a person in law, there are instances where the corporate personality of the company will be set aside, and those running the company will be held personally liable for actions they do. For instance, if the directors commit fraud on the company, they will be held personally liable. They cannot hide under the corporate veil of incorporation. Then we looked at shares, and we said shares grant you membership rights in a company, but you must ensure that your name is entered in the register of members. We looked at the different types of shares a company can have. We also looked at the different types of share capital of a company. Also, we looked at debentures. That is, when a company when a company is indebted, when a company takes out loan. We looked at the debenture holders, the different types of debentures. And we looked at the remedies available to a debenture holder. That is, where a company is unable to pay its debts to the holder, what can the holder do? We said he can file an action in court. It can also be a ground for winding up the company. There can also be a debenture holders action, and in the case of an insurance company, a group of 50 policy holders can come together to file an action against the company. In this section of corporate law, we will be looking at the organic theory of incorporation. We will also look at the Nigeria Institute of Management. We will also look at the process of winding up a company. So listen carefully and enjoy the class. Thank you. The organic theory in company law. This is a company law theory which examines the distribution or exercise of authority in the management of the affairs of a company. A company consists of two organs, that is, the board of directors and members in general meeting. Talking about members in general meeting, first of all, who can be a member? Persons not less than 18 years of age. An infant cannot be counted in determining the legal minimum number of members in a company. Then when a shareholder dies, shares transmit to the personal representative. And a company can also be a member of another company. This is because a company is an artificial person. Aliens can form a company in Nigeria and hold shares also, provided they comply with the provisions of the law with regard to alien participation. Who are members of a company? Members are those who have subscribed to the memorandum of the company, and every other person who has agreed to be a member and whose name is on the register of members. To be recognized as a member, your name must be entered in the register of members. How then do you become a member of a company? First, by subscription. By subscribing to the memorandum of the company, you become a member. These are those who sign the memorandum and articles at incorporation, and they must take up at least 20% of the total capital of. You can also become a member by allotment, where shares are offered to the public under Section 125. Those who apply and pay for them are allotted shares in the number applied for. Another method of becoming a member is by transfer. Shares of a company can be transferred from one person to another in accordance with the provisions of the articles on transfer of shares. Shares from dead persons are passed on his personal representatives through transmission of shares and not transfer of shares. Every other person who have agreed to be a member and whose name is on the register of members can be a member of a company. We mentioned members in general meeting. We have looked at members of the company. Now talking about meetings of the company. Members of the company reach decisions on how the affairs of the company will be managed at the general meetings of the company. Decisions reached at such meetings are known as resolutions. The meetings are 1. Statutory meetings. This is a meeting that holds once in the lifetime of a public company, not a private company. It must be held within 6 months of incorporating the company. Failure to hold this meeting is a ground to wind up the company. The statutory report is presented at this meeting and subsequently filed at the Commission. The statutory meeting discusses the process of incorporation and how the shares were allotted. The compliance protocols for the company are also contained in the statutory report. The annual general meeting is another type of meeting. The company must hold a general meeting no later than 15 months after the last one. Note that in the first year of incorporation, a company need not hold a general meeting until after 18 months. A 21 days notice is required to be given to every person entitled to attend and vote at the meeting, and failure to do so can render the proceedings of the meeting invalid. Issues that are discussed at the annual general meeting are divided into ordinary business and special business. The ordinary business include declaration of dividend, management report, auditor's report, appointment and removal of directors, fixing the remuneration of directors, appointment of auditors, while any matter not in the ordinary business is deemed to be a special business. Matters which fall under the special business are mostly issues that go to the root of the company. For instance, if the company wants to increase or decrease its share capital, or change its name, or borrow large funds, these matters fall under special business. And they require 2/3 majority, that is 75% of the votes, to sail through. Then you have the extraordinary general meeting. When matters arise in a company that cannot wait till the next annual general meeting to be discussed, an EGM is called to deal with such matters. The board of directors may convene this meeting, or one director if no other director is in Nigeria. The meeting can also be called by a shareholder holding not less than 1/10 of the company's paid-up capital. Then you have the board of directors. Who is a director? Under section 244, a director is appointed by the company to direct and manage the affairs of the company. Apart from the managing directors, the executive directors are not servants of the company. Now, talking about types of directors, you have the first, shadow director. This is a director on whose instructions other directors act on. He operates from the background. He is not seen. He is like an invisible hand directing the affairs of the company. He gives instructions to the board. He is not directly involved in the daily affairs of the company. Then you have the executive directors. They are appointed to run the daily affairs of the company. They have service contracts with the company most of the time. Their powers are contained in the articles or in their terms of contract. They are servants of the company, and their appointments are terminated by ordinary resolution, notwithstanding what is in their contract of service, or they are removed in accordance with the provisions of CAMA on removal of directors. Then you have alternate directors. These are directors who act in the stead of another director when that director is not available to act. If I am a director of a company and I am not available, another director can act in my absence. That one acting in my absence is the alternate director. Then you have non-executive directors. These are persons appointed based on their wealth of knowledge and experience in the managing of affairs of companies. They are not usually involved in the daily running of the company. A non-executive director can be on one or several boards of various companies. They do not have service contracts. You have life directors. When a person is appointed a director for life, it does not mean that he cannot be removed. It only means that the rule on rotation of directors does not apply to him. He continues to function as a director until he is removed, resigns, or dies. Then there's also the issue of casual vacancy. A casual vacancy occurs when a director dies, or he resigns, or retires, or is removed from the board. Such vacancy is filled by the directors till the next annual general meeting for ratification. Not all persons are qualified to act as directors of a company. For a person to be appointed, he must not be an infant, he must not be less than 18 years of age. A lunatic, a person of unsound mind, cannot be a director of a company. An insolvent person, a person who has filed for insolvency, cannot be a director of a company. Persons who have been convicted for fraud by any court of law cannot be a director of a company. Talking about vacation of office, that is where a director leaves office. What can make a director vacate office, or what are those circumstances that would warrant vacation of office? If for any reason he ceases to be a director, either he resigns, he dies, or is removed, or by virtue of share qualification, where he fails to take up shares in the company, then he can be removed and he ceases to be a director. Also, if he becomes bankrupt, here he must have filed for bankruptcy and have been declared bankrupt by the court, or if he makes arrangements with his creditors, then he can be made to vacate office as a director. Another reason why a director may vacate office is if he becomes prohibited from being a director by reason of an order made further to Section 251 of the Act. That is, if he is found guilty of fraud, or if he becomes of unsound mind, or if he resigns his office by notice in writing to the company. Now, rotation of directors. By rotation of directors, it is expected that directors retire in turn, starting with the oldest in office. This does not mean that they cannot be reappointed if they wish to continue in office. Note that the executive director who has a service contract with the company does not fall under the category of directors who retire by rotation. At the first annual general meeting of the company, all directors must retire. They are, however, reappointed. Then, at subsequent annual general meetings, a third of the directors, that is those who are oldest in office, shall retire. They can present themselves for re-election unless another person is elected to fill his place, or if it is resolved that his position will not be filled, or a resolution for his re-election has been put up and lost. The minimum age for becoming a director in any company in Nigeria is 18 years old. Then note that persons above 70 years cannot be appointed director of a public company unless he discloses his age and the members approve. How is a director removed from office? The articles or contract appointing a director provides for his removal. A director can, however, be removed from office by ordinary resolution before his term expires, irrespective of what is contained in his contract of service with the company or the articles. To remove him, a special notice must be given to him, and the director shall be entitled to be heard at the meeting in which he is sought to be removed. That means you must allow him defend himself. Any vacancy created by his removal may be filled, and the removed director is entitled to compensation for his removal. The managing director. The managing director is appointed and removed by the board. He is rewarded by salary, commission, or participation in profits, or in all of the above, or partly in either of each. Where he is removed for any reason whatsoever under Section 262, he shall have a claim for breach of contract, if any. And where he performs some service outside his contract, he shall be paid in quantum merit. This means he is paid for legitimate expense incurred in running the affairs of the company. Unless specifically provided for, there is no compensation for removal of a managing director. What is the required minimum number of directors a company may have? A company is required to have a minimum of 2 directors, while the maximum is determined by the articles of the company. What is the nature of the relationship of directors with the company? Directors have a fiduciary relationship with the company. This means they must act with utmost good faith towards the company. They must act in the best interest of the company at all times and exercise power for the purpose given and not in pursuit of self-interest. They must vote based on sound judgment at all times. This manifests mostly with regard to nominal directors. Nominal directors are those directors who are representatives of shareholders on the board of companies. Directors are not supposed to abandon their duties under the guise of power delegation. He shouldn't feel because he needs to give tax to his subordinates, then he will abandon his responsibilities to the company. He must at all times take interest in the company and take the interests of the company and employees into account. In line with the fiduciary relationship of directors with the company, the directors owe certain duties to the company. They must avoid conflict of interest. That is, he cannot act for the same purpose in 2 different companies with similar interests or products. He cannot be a director in 2 companies that do the same thing. He must exercise care and skill in the exercise of his functions at all times. The standard of skill required of him is that which is expected of one occupying the position of a director. That is, he must act in a way which a reasonable exercise, the way a reasonable director would act in similar circumstance. And this position of law applies to both executive and non-executive directors. Failure to observe reasonable care and skill grounds an action for negligence and breach of duty. That means you can sue the director if he fails to observe reasonable care and skill. Exercise of authority by directors and general meeting refers to the various ways both the directors and members in general meeting can prevent abuse of power by the other. Directors, being the controlling mind of the company, have unfettered discretion in running of the company. No one disturbs the process or manner in which they run the company. They have that unlimited authority to run the affairs of the company. And sometimes they exercise these powers to the detriment of the shareholders and the company. A lot of companies have been mismanaged due to some wrongful acts of directors. In order to curtail them, Section 262 gives members the powers to remove directors even if they are appointed for life. Members can also amend articles to curtail the directors' powers. Then also, any power not specifically given to the directors rests in the members, and the members by ordinary resolution give instructions to the directors on how to act. The Company Secretary. The office of the Company Secretary is provided for under Section 293 of the Act. Every company must have a Company Secretary. The Company Secretary is a senior officer of the company. He or she is not the person you meet at the desk, at the front desk of a company, or before you see the director of a company, the lady that sits there typing, that is called secretary. That is not the Company Secretary. The Company Secretary is a person that is appointed and removed by the board of directors. The requirement for appointing a company secretary in a private company is for the board to believe that such person is capable of being so appointed. But for a public company, for a person to be appointed a company secretary, he must be either a legal practitioner, a chartered accountant or chartered secretary, a firm of either a legal practitioner, that is a law firm, a firm of chartered accountants, a firm of chartered secretaries, or the person must have occupied the position of company secretary not less than 3 to 5 years preceding his appointment. A director can also act as a company secretary where a company does not have one. However, where an action requires a director and secretary to act, for instance, there are some resolutions that require both the company secretary and the director to sign. The same person who is signing as director cannot sign as company secretary. What is the status of the company secretary? What is his position in a company? He has an implied authority to bind his company. He makes representations on behalf of the company. As an officer of the company, he can sign contracts on behalf of the company and also act in some administrative matters. However, where an act is supposed to be done by the directors alone, the company secretary does not have a right to act except he or she is authorized by the board to act in that manner or capacity. The duties of the company secretary under Section 298 includes organizing, issuing notice for meetings, attending and taking minutes of meetings of the company, and attending external meetings on behalf of the company. He maintains the company's registers and other records. He renders proper returns and gives proper notifications to the Corporate Affairs Commission as required under the Act. He also carries out such administrative and other secretarial duties as required or directed by the directors of the company. Winding up of companies. Once a company is registered, it enjoys perpetual succession. It lives forever. It does not die. However, the life of a company can be brought to an end through the process known as winding up. Companies are wound up in different ways and for various reasons. Here, we shall examine the various ways a company can be wound up, who may petition for winding up, as well as the officials for winding up and their functions. Types of winding up. You have compulsory winding up by the court. This happens where the court exercises its power under Section 408 of the Act to put an end to the life of the company. Circumstances where a court will compulsorily wind up a company are: 1, where the company itself has by a special resolution agreed to wind up the company. That's where they have agreed that the court should wind up the company. Where the company defaults in delivering statutory reports to the Corporate Affairs Commission, the Commission can petition the court to compulsorily wind up the company. Also, where the minimum number of directors fall below the minimum legal requirement of 2, the Commission can apply for the court to wind up the company. Inability of the company to pay its debts. Any of the debenture holders can file a petition to wind up the company. Then also, where the court on just and equitable grounds feel it is necessary to wind up the company. It becomes just and equitable to compulsorily wind up a company when it has become impossible for the company to achieve its objects. That is, it can no longer carry on the business for which it was registered. Again, where there is a deadlock, that is, the directors and members can no longer reach an agreement on issues relating to the company, and the activities of the company is grounded due to the disagreements or deadlock. Also, where there is fraud, misconduct, or oppression by those running the affairs of the company, and same as degenerated into lack of confidence in the directors of the company. In these circumstances, the court can step in to wind up the company. So who are those who may petition to wind up the company? 1, the company itself can petition. Then the creditor, that is either a contingent creditor, that's someone who is presently being owed some amount of cash, or a prospective creditor, that is someone who, due to his dealings with the company, is that it will be a creditor. Such a one can petition to wind up a company. Then you have the official receiver, can also petition to wind up a company. You have the contributory, that is every person who is liable to contribute to the assets of a company in the event that it is being wound up. And it includes any person alleged to be a contributory. Then a trustee in bankruptcy can also file a petition. Then the Corporate Affairs Commission can also file a petition to wind up the company. Then a receiver, if authorized by the agreement appointing him as a receiver, can also bring a petition to wind up the company. Then all these people we have mentioned, they can all come together to file a petition to wind up the company. Then you have insurance policy holders of at least 50 in number can also come up to wind up a company. Another type of winding up is the voluntary winding up. Here you have the members' voluntary winding up and the creditors' voluntary winding up. Under the members' voluntary winding up, the company is still a going concern, but for one reason or the other, the directors and the members or the shareholders feel there is a need to wind up the company. So the company makes a declaration of solvency, after which a general meeting is called to appoint liquidators. Once the liquidators complete their work, they call on the auditors to prepare the reports, after which the liquidator convenes a general meeting of the company. Within 28 days after that meeting, copies of the accounts prepared by the auditors, statement of the meeting that shows how the winding up process was carried out are registered at the Corporate Affairs Commission. For creditors' voluntary winding up, it is the creditors of the company who decide that it has become necessary to wind up the affairs of the company. In this case, no declaration of solvency is made. Separate meetings of members and creditors must first of all hold. Meetings of creditors is presided over by the directors of the company. Liquidator and the committee of inspection are appointed. As soon as the company is wound up, the liquidator must prepare accounts showing how the winding up process was conducted. The liquidator then calls a general meeting of the creditors and members and lays the accounts before them. The last type of winding up is winding up subject to supervision of the court, as provided for under Section 486 of CAMA. Here, the company passes a resolution for voluntary winding up and then files a petition in court for an order that the winding up be supervised by the court. Then the winding up process proceeds like that of compulsory winding up. Who are the officials in winding up? You have the official receiver. First of all, receivers are persons appointed either by the court or by the secured creditors of a company with the sole aim of realizing the assets of the company and paying off the debts owed by the company. He is also required to manage the affairs of the company until the debts are paid off. Then you have the official receiver, who is appointed by the Federal High Court. He is called an official receiver because he is appointed by the court. The receiver, whether official or not, takes control and sells only assets pledged to secure money owed. And he continues to trade with the company. The directors have little role to play in running the affairs of the company while it is under receivership. And once he concludes his work, that is, once the amount owed is recovered, the company is handed back to the members. Another officer in the winding up process is the liquidator. Liquidators are appointed by the company to wind up the affairs of the company. Once appointed, he cannot do any trade or business with the company. The company cannot carry out any other business. Once liquidators are appointed, directors have no role to play in the company. Once the liquidator completes his work, the company ceases to exist. A company can be in both receivership and liquidation at the same time. That is, while trying to recover its debt, it is also in the process of winding up. A company can have one liquidator at a time, but it can have more than one receiver. That means you can have 2, 3 receivers in a company, but you can only have one liquidator. A receiver appointed by the court is known as an official receiver. Then when a company limited by guarantee is wound up, its assets are transferred to another company limited by guarantee with similar objectives as the one being wound up. The Nigeria Institute of Management. The institute was established by the Nigeria Institute of Management Establishment Act of 2003. It is a body corporate. That means it is an artificial person. What are the functions of the institute? It determines the standards of knowledge and skills to be attained by aspiring members. It also establishes and maintains a register of members. It also regulates and controls the profession of management in all aspects. The following are the different categories of members and their designation letters. You have the companion of the Nigerian Institute of Management, CNIM. You have fellow of the Nigerian Institute of Management, FNIM. You have member of the Nigerian Institute of Management, MNIM. Then you have associate member of the Nigerian Institute of Management, AMNIM. The principal officers of the institute are the president, the deputy president, the national treasurer. To become a member of the institute, an aspirant has to meet certain conditions as provided for in Section 8 of the NIM Act. He must pass the qualifying exams, and he must hold any other qualifications accepted by the institute. Then he must also qualify for enrollment under Section 14 of the Act. Then also, he must, by Section 8, be of good character. He must have attained the prescribed age, and he must not have been convicted for fraud or dishonesty. Members of the Institute's Council carry on supervision of courses and examinations. Section 10 places on members of the Council the duty to be informed of instructions given to persons attending approved courses of training. They will also be informed of the conduct of examinations and persons appointed to supervise the exams. A visitor is also appointed by the Council to report on the sufficiency of instructions given by aspiring members. Also report on the sufficiency of examinations and any other matter which the Council requests him to report on. When a member of the Institute is accused of misconduct or misbehavior, he goes through the process of professional discipline. By Section 11 of the Act, 2 bodies are set up to maintain discipline among members. First, you have the Professional Management Investigation Panel. This panel conducts investigation on alleged misconduct by a member, where it is alleged that a member has misbehaved in his capacity as a management practitioner. The panel then decides whether or not it should be referred to the tribunal. The panel is appointed by the council, and it has 2 council members and 3 non-council members. The second body is the Professional Management Disciplinary Tribunal. It determines cases brought by the Management Investigation Panel. It consists of a chairman of the council and 6 other members appointed by the council. By Section 12, the tribunal prescribes punishment for members when a member is adjudged guilty of infamous conduct, or when a member has been convicted by any court in Nigeria having power to award sentence of imprisonment. Also, when a member registers fraudulently. After a member has been adjudged guilty by the tribunal, the following sanctions may be applied on him. He may be reprimanded by the tribunal. Also, his name can be struck off the institute's register by the registrar as directed by the tribunal. However, he has a right of appeal, and until his appeal is decided, this cannot take effect. This brings us to the end of this section, and of course the end of corporate law. Section 3, we will be looking at business ethics after this short break. Thank you.